I woke up to frozen pipes and a dead furnace on the coldest morning Connecticut had seen in 20 years, with the temperature gauge in my living room reading 43 degrees and dropping fast. My name is Trevor Lawrence, and I had lived in the Meadowbrook Estates subdivision in Fairfield County for exactly 18 months. It was one of those cookie-cutter developments where every house looked almost identical, with beige siding, brown shutters, and exactly 2 approved landscaping packages to choose from. I worked as a freelance software consultant, which meant I worked from home most days. My wife had left me 6 months prior, taking our dog and most of the furniture, leaving me with a half-empty house and a mortgage that felt heavier every month. The heating system ran on oil, which was common in this part of Connecticut. The tank was buried in the backyard, and I had scheduled a delivery for that morning after realizing 2 days earlier that I was running critically low. The delivery company, Riverside Fuel, had confirmed my appointment for 8 in the morning. I had made sure to be awake and ready because the driver would need access to the fill pipe, which was located near my driveway. I stood at my kitchen window, wrapped in 2 blankets and a winter coat, sipping lukewarm coffee because even my coffee maker was struggling. At 7:55, I saw the familiar red and white Riverside Fuel truck turn onto my street. Relief flooded through me. I would have heat again within the hour. Then I saw her. Sharon Mitchell, the HOA president, stepping out of her house 3 doors down. She was wearing a puffy purple jacket that made her look like a grape, and her bleached blonde hair was pulled back so tight it probably gave her a headache. She was 52 years old, divorced twice, and had made it her life's mission to enforce every single HOA rule with the enthusiasm of a military dictator. Sharon walked directly into the middle of the street, positioning herself right in front of the oil delivery truck. The driver, a middle-aged man named Pete whom I had met during previous deliveries, stopped the truck and rolled down his window. I could not hear what they were saying from inside my house, but I could see Sharon gesturing wildly, pointing at something, then crossing her arms. I threw on boots and rushed outside, my breath creating clouds in the frigid air. As I approached, I could hear Sharon's shrill voice cutting through the morning quiet. "I do not care what appointment he has. The HOA rules clearly state that commercial vehicle access is restricted to specific hours, and early morning deliveries require 48 hours advance notice to the board." Pete looked exhausted already, and it was not even 8 in the morning yet. "Madam, this is a heating oil delivery." "The man has no heat. It is 17 degrees outside." "Rules are rules," Sharon said, her face flushed red either from the cold or from anger, probably both. "He can reschedule for an approved time slot." I reached them, my temper already rising. "Sharon, what are you doing?" "I submitted the proper form 3 days ago. I emailed it to the HOA address." "I never received any such email," she said, not even looking at me. "And even if you had sent it, you need approval, not just notification. The approval process takes 5 to 7 business days." "I am going to freeze to death in my own house," I said, trying to keep my voice level. "My pipes are already starting to freeze. This is an emergency." "Perhaps you should have thought about that before moving into a community with standards," Sharon replied. "We cannot have large commercial trucks disturbing the peace whenever they please." "What would the neighborhood look like?" Pete interjected. "Sir, I have other deliveries scheduled. I cannot wait around while you sort this out." "If I cannot make this delivery now, the next available slot is not until Friday." "Friday?" I felt panic rising in my chest. Today was Tuesday. "I will be without heat for 3 more days." "Not my problem," Sharon said. "Follow the proper procedures next time." I did follow the procedures. You are making this up as you go along. Sharon pulled out her phone and started taking pictures of the truck. This vehicle is in violation of HOA regulations. I am documenting this for the record. If you proceed with this delivery, Trevor, I will have no choice but to fine you $500 per day until the violation is remedied. Pete shook his head. I am sorry, sir. I cannot get in the middle of this. I will note on your account that delivery was refused due to HOA restrictions, but I have to move on. He looked genuinely apologetic. Wait, Pete, please. I need this oil. My house is freezing. But Pete was already putting the truck in reverse. Call the office. Maybe they can work something out for Friday. The truck backed up, turned around, and drove away, leaving me standing in the 17-degree weather with Sharon looking triumphant. You just cost me my heating oil delivery, I said, my voice shaking with anger and cold. No, you cost yourself by not following proper procedure, Sharon replied. This is exactly why we have these rules, to prevent chaos. What chaos? It is a fuel delivery. People get fuel delivered all the time. Not without proper authorization, they do not. Not in Meadowbrook Estates. She turned and started walking back toward her house. I suggest you submit a proper request and wait for approval like everyone else. I stormed back into my freezing house, slamming the door hard enough to rattle the windows. My hands were shaking as I pulled out my laptop and found the email I had sent 3 days prior. There it was, sent to the official HOA email address listed on all their documentation, with the proper form attached. Subject line: Heating oil delivery request 142 Maple Drive, January 14th. Timestamp showed I had sent it at 2:30 in the afternoon on Saturday. I forwarded the email to Sharon's personal email address, which I had from previous HOA correspondence. Then I called Riverside Fuel. This is Trevor Lawrence on Maple Drive. Your driver just left because my HOA president physically blocked the delivery. The woman on the phone sighed. Yes, Pete just radioed that in. I am very sorry, Mr. Lawrence. We deal with HOA issues sometimes, but usually we can work it out. Unfortunately, we are completely booked until Friday afternoon. We are short-staffed this week, and with the cold snap, everyone is ordering emergency deliveries. What am I supposed to do until Friday? I have no heat. Do you have any space heaters? One small one. Use it in whatever room you spend the most time in. Keep doors closed to conserve what warmth you can generate, and keep your faucets dripping so your pipes do not freeze and burst. That would be much more expensive than a few days without heat. I thanked her and hung up, feeling helpless. Then I did something I probably should not have done. I posted about the situation on the neighborhood Facebook group. Within 20 minutes, I had 30 comments. Most of them were supportive, sharing their own horror stories about Sharon and the HOA board. A few people suggested I contact a lawyer. One person mentioned that blocking emergency services or essential utilities might actually be illegal. That comment stuck with me. I spent the next hour researching Connecticut laws regarding HOA powers and limitations. What I found was interesting. While HOAs in Connecticut had broad authority to enforce covenants and restrictions, they could not interfere with essential utilities or create health and safety hazards. Heating in winter definitely qualified as essential, and creating a situation where someone's pipes could freeze and burst could be considered a safety hazard. I called a lawyer whose name I found through a local legal aid website. His name was Marcus Freeman, and he specialized in property law and HOA disputes. His secretary told me he could see me that afternoon at 3. The rest of the morning was miserable. I set up my one space heater in my home office, where I had to work on a project deadline for a client. I wore 3 layers of clothing and kept a blanket over my legs. My fingers kept getting too cold to type effectively. Around noon, I got an email from Sharon. "Trevor, I have now reviewed the email you claim to have sent. While it appears you did send something on Saturday, the attached form was not filled out completely. You failed to include the estimated time of the delivery completion. Therefore, your request is denied. Please resubmit with all required information and wait for the standard processing time. Regards, Sharon Mitchell, HOA President." I stared at the email in disbelief. The form had a field for estimated completion time, but it was not marked as required. It was one of those optional fields that most people left blank, because how would anyone know exactly how long an oil delivery would take? Usually between 15 and 30 minutes depending on how much fuel was needed, but it varied. I responded immediately. "Sharon, that field is not marked as required on the form. I included all mandatory information. Furthermore, this is an emergency situation affecting my health and safety. I need heat restored immediately. I am requesting that you grant retroactive approval for this morning's delivery and allow the company to return." Her response came back within 10 minutes. "The field is required as of the board meeting last month. We updated our internal requirements but have not yet updated the form. You should have attended the meeting if you wanted to stay informed. Request denied." I wanted to throw my computer across the room. Instead, I took screenshots of everything and saved all the emails to a folder. At 3 o'clock, I drove to Marcus Freeman's office in downtown Fairfield. The heat in my car felt like heaven after spending hours in my cold house. Marcus was a tall black man in his early 40s with graying temples and a no-nonsense demeanor. I explained the entire situation while he took notes. "You have documentation of all of this?" he asked. I showed him the emails, the original form I had submitted, the Facebook posts, and photos I had taken of my thermostat showing the dropping temperature inside my house. Marcus leaned back in his chair. "This is actually pretty clear-cut. HOAs have to operate within reason, and they absolutely cannot create health and safety hazards. Leaving you without heat in this weather crosses that line. They also cannot retroactively apply new requirements without proper notice. If they changed the form requirements last month, they needed to update the actual form and notify all residents. So what can I do? We can file for an emergency injunction compelling the HOA to allow the delivery. Given the circumstances, a judge would likely grant it quickly. We can also pursue damages for any losses you incur as a result of their actions." Damages. Are you losing work because of this situation? Having trouble meeting deadlines because you cannot work effectively in a freezing house? I nodded slowly. "Actually, yes. I have a project due Thursday for a client. It is worth $5,000, and I am behind schedule because I keep having to stop and warm up my hands. If I do not deliver on time, the contract has a penalty clause. I lose 20% of the payment for each day of delay. Document everything. Keep a detailed log of your work hours, productivity issues, anything affected by the lack of heat. We will need that." Marcus pulled out a legal pad. "I can file the emergency motion this afternoon. We will request an expedited hearing, probably tomorrow or Thursday. In the meantime, document everything Sharon does or says. Do not engage with her beyond necessary communication. Let everything go through writing if possible. What about the HOA rules she is citing? Are they actually valid? Some HOAs do have restrictions on commercial vehicle access, but they have to be reasonable, and they cannot override basic needs." Heating oil delivery is not the same as someone running a commercial trucking business out of their driveway. The fact that she physically blocked the truck is also problematic. That might actually constitute interference with business operations, which could have legal implications for her personally, not just the HOA. I left Marcus's office feeling slightly better, but I still had to go home to my freezing house. That evening, the temperature inside dropped to 39 degrees. I slept in my office with the space heater running, wearing a winter coat and using every blanket I owned. It was the worst night's sleep I had had in years. The next morning, Marcus called me at 8. "We got the hearing. Today at 2 this afternoon. Judge Patricia Henderson. She has a reputation for not tolerating HOA overreach, so that is good for us. Be at the courthouse at 1:30. Dress professionally. Bring any additional documentation you have." I spent the morning compiling everything I could. I printed out the weather reports showing the extreme cold. I documented my thermostat readings every hour. I wrote a detailed account of how the cold was affecting my work. I had already missed a check-in call with my client yesterday because I had been at the lawyer's office, and they were getting concerned about the project timeline. At 1:30, I met Marcus at the Fairfield County Courthouse. Sharon was already there with her own lawyer, a stern-looking woman in her 60s named Patricia Holbrook. Sharon looked confident, even smug. She was wearing a business suit and had toned down her usual aggressive makeup. We were called into Judge Henderson's courtroom at 2:15. Judge Henderson was a woman in her mid-50s with short gray hair and reading glasses perched on her nose. She looked at the papers in front of her with a frown. "Let me make sure I understand this correctly," she said. "Mr. Lawrence, you are requesting an emergency order compelling your HOA to allow a heating oil delivery to your residence. Is that correct?" "Yes, Your Honor," Marcus said, standing. "My client has been without heat for 2 days in record-breaking cold weather. His HOA president physically blocked a scheduled delivery and is refusing to allow the delivery company access, citing HOA regulations." Judge Henderson turned to Sharon's lawyer. "Ms. Holbrook, what is your response?" Patricia Holbrook stood. "Your Honor, the HOA has legitimate rules governing commercial vehicle access. Mr. Lawrence failed to follow proper procedures for requesting such access. The HOA is simply enforcing its established regulations. In 17-degree weather, when the man has no heat." Judge Henderson's tone was sharp. The HOA cannot make exceptions simply because someone finds the rules inconvenient. If we allowed that, we would have chaos. Mr. Lawrence had ample opportunity to ensure his fuel supply was adequate before the cold snap. I felt my blood pressure rising, but Marcus put a hand on my arm, signaling me to stay calm. Judge Henderson turned to me. "Mr. Lawrence, when did you schedule this delivery?" I stood. "Your Honor, I scheduled it last Thursday when I realized my tank was getting low. I submitted the proper request form to the HOA on Saturday, 3 days before the scheduled delivery. I have the email and the form here. May I see it?" Marcus handed over the documentation. Judge Henderson read through it carefully. "Miss Mitchell," the judge said, looking at Sharon. "Did you receive this request?" Sharon stood, and her lawyer looked uncomfortable. "I did receive an email, Your Honor, but the form was incomplete. There is a required field for estimated completion time that was not filled out. Where on this form does it indicate that field is required?" Judge Henderson held up the form. "It is an internal requirement that was established at our January board meeting. But the form itself does not show it as required. There is no asterisk, no note indicating it is mandatory." Judge Henderson set the form down. "Miss Mitchell, did you update the form after establishing this new requirement?" Sharon hesitated. We have not had time to update the physical form yet, but all residents are expected to attend board meetings and stay informed of policy changes. Mr. Lawrence, did you attend this board meeting? No, Your Honor. I was not aware of it. I did not receive any notice. Judge Henderson looked at Sharon's lawyer. Miss Holbrook, did the HOA provide proper notice of this meeting to all residents as required by Connecticut HOA statutes? Patricia Holbrook's face had gone pale. I would need to verify the notice procedures, Your Honor. I am going to take that as a no. Judge Henderson removed her glasses. Let me be very clear about something. HOAs are granted certain powers by statute, but those powers are not unlimited. They must operate reasonably and within the bounds of law. Leaving a resident without heat in dangerous weather conditions is not reasonable. It creates a health and safety hazard. Your Honor, if I may, Sharon's lawyer started, but Judge Henderson held up her hand. I am not finished. Furthermore, you cannot enforce requirements that are not clearly communicated. If you change a form requirement, you must update the form and provide notice to residents. You cannot expect people to know about internal policy changes that were made at meetings they were not properly notified about. That is not how this works. Sharon's face was turning red. She whispered something urgently to her lawyer. Judge Henderson continued. Mr. Lawrence has demonstrated that he made a good faith effort to comply with HOA procedures. He submitted a request 3 days in advance. The fact that he did not fill out a field that was not marked as required is not grounds for denying essential utility access. I am granting the emergency injunction. Miss Mitchell, you and your HOA are hereby ordered to allow immediate access for heating oil delivery to Mr. Lawrence's property. You are further ordered to not interfere with said delivery in any way. Your Honor, the HOA has a right to enforce its covenants, Patricia Holbrook protested. The HOA has a right to enforce reasonable restrictions that do not violate health and safety standards. This is not reasonable. The order stands. Judge Henderson made a note in her file. Now I see there is also a request for damages. Mr. Lawrence, you are claiming lost wages. Explain. Marcus stood again. Your Honor, my client is a freelance software consultant who works from home. The lack of heat has made it impossible for him to work effectively. He has a project with a deadline this Thursday. The contract includes penalty clauses for late delivery. He stands to lose a significant portion of his payment if he cannot complete the work on time due to the conditions in his home. How much are we talking about? The contract is for $5,000. The penalty is 20% per day of delay. Mr. Lawrence has already lost approximately 8 hours of work time due to the cold conditions making it impossible to work. If he misses the Thursday deadline, he loses at least $1,000, potentially more if the delay extends. Judge Henderson turned to Sharon. Miss Mitchell, did you consider the potential consequences of your actions when you blocked this delivery? Sharon stood again, and now her confidence was cracking. Your Honor, I was simply enforcing the rules. I had no way of knowing about his work situation. You knew he had no heat in 17-degree weather. That should have been enough. Judge Henderson looked at the papers again. I am ordering a full hearing on the damages claim for 2 weeks from today. In the meantime, Mr. Lawrence, I suggest you document everything meticulously. Keep records of all work time lost, any penalties you incur, any additional expenses you face as a result of this situation. Yes, Your Honor. Miss Mitchell, I strongly suggest you and your HOA board consult with your lawyer about the scope and limits of your authority. This kind of overreach can result in significant liability for the association and potentially for board members personally if it is found to be willful misconduct. Sharon's face went pale. Personally, HOA board members are not immune from personal liability when they act beyond the scope of their authority, or in ways that cause harm to residents. If Mr. Lawrence can demonstrate that you knowingly and deliberately caused him financial harm by unreasonably blocking essential services, you could be personally liable for damages. That is something you should discuss with your attorney. The hearing wrapped up shortly after that. As we left the courtroom, Sharon tried to approach me, but her lawyer pulled her away, speaking to her in urgent, hushed tones. Marcus and I stepped outside into the cold afternoon. "That went about as well as we could have hoped," he said. "Get that oil delivered immediately. Document the temperature restoration in your house. Keep detailed work logs for the next 2 weeks. We need to build an airtight case for the damages hearing." I called Riverside Fuel from the parking lot. They agreed to send a truck the next morning, Thursday, at 8. I sent Sharon an email with the delivery details, copying Marcus and her lawyer, stating that this delivery was being made pursuant to the court order, and that any interference would be in violation of said order. Sharon responded an hour later with a terse, "Noted." Thursday morning, I watched nervously from my window as the Riverside truck pulled up at exactly 8 o'clock. Pete was driving again. I went outside to meet him, and we both looked down the street toward Sharon's house. Her car was in the driveway, but she did not emerge. "Looks like we are clear," Pete said. "Let me get this done quick just in case." The delivery took 22 minutes. Pete filled my tank completely and I paid extra for a top-off, wanting to avoid this situation for as long as possible. Sharon never appeared. When Pete drove away, I felt a wave of relief. Within 2 hours, my house started to warm up. The furnace kicked on and ran steadily, and by noon, the inside temperature had climbed back to a comfortable 68 degrees. It felt like a miracle. I spent the rest of Thursday and all of Friday working obsessively on my client project. I managed to complete it by Friday evening, exactly 1 day late. The client was understanding when I explained the situation, but the contract was clear. They paid me $4,000 instead of $5,000, invoking the penalty clause for the 1-day delay. I documented everything. I had photographs of my thermostat showing the cold temperatures. I had work logs showing the hours I had lost. I had the email chain with my client showing the deadline and the penalty. I had the contract showing the penalty clause. I had receipts for additional expenses, including having to buy extra blankets and hand warmers to try to keep working. Over the next 2 weeks, I avoided Sharon as much as possible. I saw her occasionally in the neighborhood, usually getting her mail or leaving for some errand. She never looked in my direction. The neighborhood Facebook group was buzzing with the story. Several other residents reached out to me privately, sharing their own nightmares with Sharon and the HOA board. One person mentioned that Sharon had tried to fine them for having their trash cans visible from the street for more than 2 hours on garbage day. Another said Sharon had measured their grass with a ruler to verify it was not over the maximum allowed height of 3 inches. The damages hearing was scheduled for a Thursday afternoon. Marcus and I met that morning to review everything one final time. He had prepared a detailed breakdown of my losses. $1,000 in lost wages from the delayed project, $300 for the emergency legal fees and filing costs, $150 for additional space heaters and supplies purchased to try to maintain working conditions, approximately $200 in additional electricity costs from running the space heater continuously for 3 days. We are asking for a total of $1,650, plus legal fees, Marcus said. The judge might not award everything, but we have documentation for all of it. We are also asking that the HOA reimburse your attorney fees since their unreasonable actions necessitated legal intervention. At the courthouse, Sharon showed up with Patricia Holbrook again. Sharon looked nervous now, none of the earlier smugness visible. We went through the same courtroom process, checking in and waiting for our case to be called. Judge Henderson reviewed the file when we were finally before her. Mr. Lawrence, you are seeking damages for lost wages and expenses incurred as a result of the HOA's refusal to allow your heating oil delivery. Correct? Yes, Your Honor. I have reviewed your documentation. It appears very thorough. You are claiming $1,000 in lost contract wages due to being 1 day late on a project deadline. Do you have evidence that this delay was directly caused by the lack of heat? Marcus stood. Yes, Your Honor. My client kept detailed work logs showing that he lost approximately 8 hours of productive work time over the 3-day period without heat. His hands would become too cold to type effectively. He had to take frequent breaks to try to warm up. In his normal work environment, he would have completed the project on schedule. The documentation shows that once heat was restored, he was able to complete the project within 24 hours of intensive work. Ms. Holbrook, does the HOA dispute these claims? Sharon's lawyer stood. Your Honor, while we acknowledge that Mr. Lawrence was inconvenienced, we question whether the HOA should be liable for what amounts to indirect economic losses. He is claiming damages for a contract penalty, which is several steps removed from the HOA's actions. Not several steps, Judge Henderson said. 1 step. The HOA's actions directly prevented him from working effectively. The contract penalty was a foreseeable consequence of that delay. This is not some speculative future harm. This is documented financial loss. She reviewed more papers. I am also seeing claims for emergency legal fees, additional supplies, and utility costs. These all appear reasonable and well documented. Patricia Holbrook tried again. Your Honor, the HOA was acting in good faith to enforce its regulations. There was no intent to cause harm to Mr. Lawrence. Good faith requires reasonableness, Ms. Holbrook. Blocking a heating oil delivery in dangerous winter weather is not reasonable, regardless of intent. The HOA had multiple opportunities to resolve this situation without creating a health hazard and a financial burden for Mr. Lawrence. Miss Mitchell chose to escalate rather than exercise common sense and basic human decency. I glanced at Sharon. She was staring at the table in front of her, her face flushed. Judge Henderson continued. I am awarding Mr. Lawrence the full amount of his claimed damages. $1,000 for lost wages, $300 for legal fees related to the emergency injunction, $150 for supplies, $200 for additional utility costs. The total comes to $1,650. Additionally, I am ordering the HOA to reimburse Mr. Lawrence's attorney fees for this damages hearing, which I understand amount to approximately $800. Marcus nodded. That is correct, Your Honor. So the total judgment against the Meadowbrook Estates HOA is $2,450 to be paid to Mr. Lawrence within 30 days. Sharon made a small sound, almost a gasp. Patricia Holbrook put a hand on her arm. Furthermore, Judge Henderson said, and her tone became even more serious, I am ordering the Meadowbrook Estates HOA Board to undergo training on HOA law and the limits of their authority. The Connecticut Bar Association offers such programs. I want documentation that the entire board has completed this training within 60 days. Your Honor, Patricia Holbrook said, that seems excessive. No, What is excessive is an HOA president physically blocking essential utility services in dangerous weather, and then attempting to justify it with poorly communicated and unreasonable interpretations of community rules. If anything, I am being lenient. The alternative is that I refer this matter to the State Consumer Protection Agency for investigation into potential HOA abuse, which could result in much more significant consequences for your client. Sharon's eyes were getting wet now. I could see her fighting back tears. You understand, Miss Mitchell? Judge Henderson asked directly. Sharon stood shakily. Yes, Your Honor. I hope you do. Because if Mr. Lawrence or any other resident of your community ends up back in this courtroom with another complaint about unreasonable HOA actions, I will not be so understanding. HOAs exist to maintain property values and community standards, not to make residents' lives miserable. Remember that. Yes, Your Honor. The hearing ended. As we filed out of the courtroom, Sharon was crying openly now, tears running down her face. Patricia Holbrook was talking to her quietly, probably explaining the implications of the judgment. Marcus and I walked to his car. That was a complete victory, he said. Not only did you get full damages, but she is going to be personally humiliated when the HOA has to pay out this judgment. Board members hate that because it makes them look bad to the community. Do you think she will retaliate somehow? If she is smart, no. Any further action against you now could be seen as retaliation, and that would make things much worse for her. Plus, she has been publicly slapped down by a judge. That tends to make people more careful. Over the next few weeks, I watched the fallout unfold. The neighborhood Facebook group exploded when word got out about the judgment. Several residents started asking questions about other HOA actions and whether they were actually legal. Someone requested copies of the HOA board meeting minutes for the past year. Another person started a petition to recall Sharon from the board. Sharon became noticeably scarce in the neighborhood. Her car was often gone, and when she was home, she never came outside. I heard through the neighborhood gossip chain that she had taken a temporary leave of absence from her HOA duties due to stress. The HOA sent me a check for $2,450 exactly 28 days after the judgment, 2 days before the deadline. It came with a terse letter signed by the vice president of the board, stating that the payment was being made pursuant to court order and should not be construed as an admission of wrongdoing. I found that amusing since the entire court case had already established wrongdoing, but I cashed the check anyway. In mid-March, I received a notice that the Meadowbrook Estates HOA board would be holding a special election. Sharon had resigned as president, citing personal reasons. The position would be filled by vote at the next general meeting. Several residents had already announced their intention to run, and the campaign promises all centered around reforming HOA procedures and ensuring reasonable enforcement of rules. I ran into Sharon once more, in early April. I was at the grocery store in town, and I saw her in the produce section. She saw me at the same time, and for a moment we just looked at each other. She looked older somehow, more tired. The aggressive confidence that had defined her was gone. She walked over to me slowly. "Trevor, can I talk to you for a minute?" I was surprised but nodded. "Sure." She took a breath. "I wanted to apologize for all of it. I was wrong. I was so focused on the rules and maintaining control that I lost sight of common sense and basic humanity. You were suffering and I made it worse." "I am sorry. I had not expected this." "Thank you for saying that." The judge was right. I abused my position. I let the power go to my head. I thought being strict and inflexible made me a good HOA president, but it just made me cruel. Her voice cracked slightly. "I have been in therapy." trying to understand why I acted that way, trying to be better. "I appreciate you telling me this," I said, and I meant it. "For what it is worth, I did not want to destroy your life. I just wanted heat in my house." "I know. And I nearly caused you to freeze and lose your income because of my ego." She wiped at her eyes. "The whole neighborhood hates me now. I probably deserve it. People have short memories. This will blow over eventually. Maybe, but I will remember it. That is probably what matters." She started to walk away, then turned back. "For what it is worth, I am glad you fought back. Someone needed to. I would probably still be acting that way otherwise." I watched her walk away, pushing her shopping cart slowly through the store. I felt an unexpected twinge of sympathy. She had been genuinely awful, but at least she was trying to acknowledge it and change. That was more than a lot of people in her position would do. The new HOA president was elected in May. His name was Robert Torres, and he was a retired teacher in his 60s who had lived in Meadowbrook Estates since it was built. His first action was to establish a complete review of all HOA rules and procedures. He created a committee of residents to evaluate which rules were necessary and reasonable, and which were excessive or outdated. One of the first rules to be reformed was the commercial vehicle access policy. The new version was simple. Residents could schedule deliveries of essential services like fuel, propane, or septic pumping at any time by providing 24 hours notice via email. No approval process, no 5 to 7 day waiting period, just a courtesy notification so the HOA knew to expect a larger truck in the neighborhood. The form was updated to include only truly necessary information, and all required fields were clearly marked. By summer, Meadowbrook Estates felt like a different place. The Facebook group became less of a complaint forum and more of a community hub. People organized a neighborhood barbecue. Someone started a book club. The oppressive atmosphere that Sharon had created was lifting, and people were actually enjoying living there. I received an email in late June from Robert Torres, asking if I would be willing to join the HOA Rules Review Committee. Apparently, my experience had given me valuable insight into how rules could be abused and what safeguards were needed. I thought about it for a few days before agreeing. It seemed like a good way to ensure what happened to me would not happen to anyone else. Sharon moved out of Meadowbrook Estates in August. I heard she sold her house and moved to a different town, somewhere north closer to the Massachusetts border. Some people said good riddance. Others, myself included, wished her well. She had learned a hard lesson, and I hoped she was finding peace somewhere else. My client ended up being so impressed with the final project that they hired me for additional work, more than making up for the penalty I had paid. My home stayed warm through the following winter, with regular oil deliveries scheduled and completed without incident. I even got to know Pete, the delivery driver, pretty well. He told me stories of other nightmare HOA situations he had encountered, though he said mine was definitely in the top 5. The whole experience taught me several important lessons. First, that HOA rules need to be balanced with common sense and basic human compassion. Second, that standing up to unreasonable authority is sometimes necessary, even when it is uncomfortable and expensive. Third, that documentation is everything. Without those emails, that original form submission, and those detailed work logs, I never would have won my case. Most importantly, I learned that communities work best when the people in charge remember they are supposed to serve the residents, not rule over them. Sharon had forgotten that, and it cost her position, her reputation, and the respect of her neighbors. Robert Torres understood it, and under his leadership, Meadowbrook Estates actually became a pleasant place to live. I still live here today. The house is not much, still the same beige siding and brown shutters, still half empty after my wife left. But it is mine, and it stays warm in the winter, and I do not have to fight with anyone to get fuel delivered. Sometimes that is enough. The legal documents from my case are filed away in a folder in my office, but I have not looked at them in over a year. They represent a difficult period, but also a time when I stood up for myself and won. When I had to work in that freezing house, wearing 3 layers and a coat, struggling to type with numb fingers, I felt helpless. By the time I walked out of that courthouse with a judgment in my favor, I felt empowered. Sharon's apology in the grocery store was unexpected, but it provided closure I did not know I needed. She was not a villain in a simple story. She was a person who made bad choices and hurt people, and then had to face consequences. Her willingness to acknowledge that and try to change gave me hope that people can grow, even after serious mistakes. The $2,450 from the judgment went into my savings account. I thought about using it for something special, a vacation or a new computer, but instead, I just saved it. It represents more than money to me. It represents standing up for myself, refusing to accept unreasonable treatment, and holding someone accountable for their actions. The Meadowbrook Estates bylaws that were reformed after my case became a model for other HOAs in the area. Robert Torres presented them at a regional HOA conference, and several other communities adopted similar changes. My lawyer, Marcus Freeman, told me he has received multiple calls from residents in other HOAs who heard about my case and wanted help with their own situations. The ripple effects of one person refusing to accept unreasonable treatment extended far beyond my frozen house on Maple Drive. Sometimes I see people at the grocery store or the hardware store, and they recognize me as that guy who fought the HOA. Usually they want to shake my hand or tell me their own HOA horror story. I listen politely, offer advice when I can, and always emphasize the importance of documentation. Most HOA disputes never make it to court because people do not have the evidence to back up their claims. The neighborhood barbecue became an annual event. At the second one, I was grilling burgers when Robert Torres came over with a beer in hand. "You know," he said, "you changed this place. Before your case, everyone was scared of the HOA. Now people actually participate, ask questions, hold us accountable. It is what a community should be." I flipped a burger and shrugged. I just wanted heat in my house. Sometimes that is how it starts. One person refusing to accept an unreasonable situation. Next thing you know, the whole system changes. Looking back on those cold days in January, shivering in my house, watching my breath fog in my own living room, I never imagined it would lead to widespread HOA reform and a court judgment that would be cited in other cases. I was just a guy who wanted to work comfortably in his own home, who thought it was unreasonable to freeze because of bureaucratic overreach. The judge's words stuck with me. HOAs exist to maintain property values and community standards, not to make residents' lives miserable. That simple statement captured everything wrong with how Sharon had operated, and everything right about how Robert was now running things. Rules should serve people, not the other way around. My work as a software consultant continued successfully. I delivered projects on time, built my client base, and slowly started refurnishing my house. I adopted a dog from the local shelter, a medium-sized mutt named Cooper who loves walks around the neighborhood. Sharon's old house is now occupied by a young family with 2 kids. They painted the shutters blue, which would have given Sharon a heart attack since brown was the approved color. The new HOA board approved the change without issue after they provided a sample of the paint color. Life in Meadowbrook Estates is not perfect, but it is better. People feel comfortable calling the HOA with concerns without fear of arbitrary punishment. Rules are enforced when necessary, but with understanding and flexibility. The neighborhood has become a community, rather than just a collection of houses monitored by an authoritarian board. I sometimes wonder what Sharon is doing now, whether she found peace in her new town, whether she carried the lessons from our conflict with her. I hope she did. I do not wish her ill. She was a person who made mistakes, faced consequences, and tried to make amends. That is more human than a lot of people manage. The heating oil tank in my backyard gets filled regularly now, usually in October before the cold weather hits, and then again in February, if it is a particularly harsh winter. Every time I schedule a delivery, I send a simple notification email to the HOA, and every time I get a simple acknowledgement back. No drama, no blocked trucks, no court dates. Just a normal transaction between a homeowner and his community association. That is how it always should have been. And now, thanks to one cold January and a judge who understood the limits of HOA authority, that is how it is. Sometimes standing up to unreasonable authority is uncomfortable and expensive and stressful. But sometimes it is necessary. And sometimes it makes things better not just for you, but for everyone who comes after. I still have that original email saved, the one I sent on that Saturday afternoon, requesting permission for a heating oil delivery. The subject line is simple. Heating oil delivery request 142 Maple Drive, January 14th. That email started everything. A chain of events that led to court hearings and judgments and HOA reforms and ultimately to a better community. It is funny how the small moments in life can cascade into significant changes. I was not trying to be a crusader or a reformer. I was just cold and wanted heat. But by refusing to accept unreasonable treatment and being willing to fight back with documentation and legal action, I ended up changing an entire community for the better. That is the power of standing up for yourself, of refusing to be bullied by people who abuse small amounts of authority. The space heater I used during those 3 frozen days is now in my basement, a backup in case of emergency. Every time I walk past it, I remember those miserable hours working in layers of clothing, my fingers stiff with cold, my breath visible in my own house. I remember the frustration and helplessness, but I also remember the decision to fight back, to get a lawyer, to document everything and take it to court. That decision made all the difference. Not just for me, but for every resident of Meadowbrook Estates who benefits from the reformed rules and reasonable enforcement. Not just for our community, but for other HOAs that adopted similar reforms. One person standing up to unreasonable authority created ripples that extended far beyond what I could have imagined when I first called Marcus Freeman's office. This is my story, the story of how an HOA Karen blocked my heating oil delivery and then cried when a judge ordered her to pay my lost wages. But it is also a story about the importance of documentation, the power of standing up for yourself, and the possibility of change when people refuse to accept unreasonable treatment. It is a reminder that even small acts of resistance against arbitrary authority can have meaningful impacts, and that communities work best when rules serve people rather than people serving rules.